Please disregard that for a couple of minutes. We'll call the General Law Subcommittee number 1 to order. Please open the roll.
Right there, Mr. Chair.
Okay.
Mr. Chair. Wait a minute.
Okay, we do have a quorum. Please close the roll. Okay, thank you. First, we have Senator Sproul, Senate Bill 786. Seniority matters, Senator. That's right.
Mr. Chairman, Senate Bill 786. 786 is the bill focused on protecting citizens of the Commonwealth from the dangers of mold. Mold will grow where there is moisture anywhere. Mold like asbestos and lead paint can cause individuals to have significant lasting health impact, especially among children. In Virginia, those that inspect asbestos and lead paint are required to adhere to a licensure requirement developed by the Virginia Board of Asbestos, Lead, and Home Inspection. There is no such requirement for those assessed in mold. This bill simply adds mold to the board and give the board discretion as to how they want to implement such license. By doing this, citizens will be able to ensure that those performing mold-related work in their homes have the education and knowledge of what's going on. Thank you.
Thank you, Senator. Before we take any testimony from the public, do we have any questions from the committee? Okay, we have no questions. Okay, before we take any testimony from anyone in the room, we do have one person signed online, Mr. Bradshaw.
Yes, thank you, Mr. Chairman and members of the subcommittee. So my name is Robbie Bradshaw on behalf of the IICRC. We're a nonprofit organization that develops standards and certifications for the cleaning and restoration industry, including mold remediation. We asked the subcommittee to vote yes on this bill. So mold grows where there's moisture. And with the way the climate's moving, we're going to see more floods, more hurricanes, and more property damage. And as the senator alluded to, mold can cause lingering health effects, especially amongst children and those with immunocompromised. And it's a danger to the health, safety, and welfare of the public at large. And that's why assuring that mold remediation is done properly and correctly the first time is essential. And we ask the members of the subcommittee to vote yes on SB 786. Thank you.
Okay, thank you. Do we have anyone here in the room to speak in favor or against the bill? Okay, we have, yes, sir.
Good afternoon, Mr. Chair. Excuse me, members of the committee. Mitch Mellis, Agency Director with DPOR. I do want to bring up a little bit of history here with this program. Mold remediators, they were licensed in 2009 by the General Assembly. There was an enactment date of 2011. The program was built, regulations established, and in 2012 the program was deregulated. The Code of Virginia sets a pretty high and clear standard regarding the regulation of new licenses and new occupations, essentially outlining that there should be a clear risk of public harm and not one based on tenuous circumstances or argument. In this instance, we are unaware of any reports or information of public harm and how the connection between that public harm and the licensure of these individuals would actually result in the public's benefit. There are certifications out there. This actual bill, as my understanding, the Institute of Inspection and Cleaning and Restoration is named in the bill as a certifying body to obtain that license. Generally speaking, we do oppose that approach. We don't think it's helpful to name a particular certifying body. What that oftentimes does is route everybody to that certifying body to become licensed. And in addition to the general broad societal or economic costs, there are also costs to the agency that we have begun taking a notice of. We believe focusing on the actual dangers that the public are known and not based on tenuous arguments such as contractors, real estate agents, skincare, and others where there's true public harm. Our operations is better focused on those. And we are not aware of mold remediators currently licensed in New York, Florida, Tennessee, Texas, and Louisiana, 5 states. We do oppose this bill and ask that you oppose the bill. Thank you.
Okay.
Mr. Chairman, may I ask a
Yes,
question?
sir. Yes, sir.
Mr. Chairman, to the committee, if you don't have a board to check this out, then not this one that he's talking about, then who? That's my question. Okay, if you can't let the Board of Asbestos had a problem with asbestos a long time ago, they had to do something, so they did that. Lead, the same problem. It started from there. So my question, so if this board doesn't do it, then okay, let's not use them. Let's tell me who can inspect the water problem we have all across Virginia when it's mold. Tell me, I use somebody else. I don't have to use them. That's one that's doing it now. Give me another name. I use that name. But you just can't say there's no problem. All of you are aware you have a problem with mold. So if you don't want to use this company, give me somebody else. I'll take it. Thank you, sir.
Thank you, Senator. Chairman Leftwich.
So I'm aware of the arguments in opposition to the bill, but I can just tell you that, in my practice as an attorney in Hampton Roads, our firm's handled several lawsuits where we represented homeowners who had someone who was not qualified coming in, inspecting, saying the home was cleared, and their children have had some pretty violent reactions to the mold. So despite some of the concerns that I've heard, I intend to support the bill and move that it be reported.
Okay, we have a motion and a second to report the bill. Please vote. Okay, the bill passes 6-1. Thank you, Senator.
Thank you, Mr. Chairman. Mr. Chairman, Mr. Walker, I'm sorry, but Jay is my number 1 man. You number 2.
I'll take any compliments, Senator. Thank you.
Okay, next we have Senator Barker, Senate Bill 1341.
Hello, Mr. Chairman and members of the subcommittee here. So, what I have here is Senate Bill 1341, and it deals with appointing where there are unincorporated bodies, societies, groups, associations, or posts that are seeking the consistency in terms of whether or not trustees are appointed. What we have in the code right now clearly gives some discretion to the circuit courts to appoint trustees for these types of organizations. And I've had a constituent who is head of a Masonic lodge, and that's one of the groups that has had a lot of challenges to this. What we have now is the circuit courts are allowed to appoint trustees. There's clearly, when somebody gives a gift or something, then they would be able to deal with that. But what they're looking for is to be able to have a consistent approach to things and to have the circuit court judges make the appointments of the trustees to oversee the assets of the organizations that we have. We used to have the same issue in terms of religious organizations, churches, et cetera. They were not allowed to be incorporated, just like a lot of these groups are not allowed to be incorporated. And so a lot of them sort of struggled along. And that was taken care of, I think, probably 25, 30 years ago in providing a consistency of appointments of trustees to the religious organizations such as the churches and synagogues, et cetera. What we're looking for here is to have a comparable system operate. There are a lot of jurisdictions around the Commonwealth where the circuit courts respond and make the appointments in every case when they're asked to do so. But we also have some parts of Virginia and some jurisdictions where the circuit courts do not routinely provide that. And some of these organizations have really had some issues in terms of how to handle a lot of different things when there is no board of trustees to handle that. And that's all they're asking for here is to get the judge, make sure that the message is sent to the judges that yes, you can appoint trustees and you should to be able to protect the assets.
Okay, thank you, Senator Barker. Do we have any questions from the committee? Okay, we have no one signed up online. Is there anyone here speaking for or against the bill? Okay, I'll entertain a motion. We have a motion to report with a second. Please vote. Bill passes 7-0. Thank you.
Thank you very much.
Thank you. Have a good day. Okay, next, Senator DeSteph. We have Senate Bill 1082.
Mr. Chairman, members of the committee, thank you very much. Hope you're having a great day today. Senate Bill 1082 allows Department of Veterans Services the opportunity to contract with any hyperbaric clinic providing medical grade 100% oxygen in U.S. FDA administered and approved chambers in the Commonwealth or any hospital in the Commonwealth. That furnishes a comprehensive treatment program that includes, and I wish they would have reordered this, and I'll tell you why in a minute. That includes hyperbaric oxygen therapy, psychotherapy, and medication from an accredited program to any veteran in the Commonwealth who has a certified by the Department of Veterans Affairs or any branch of the United States Armed Forces of having TBI or post-traumatic stress disorder or any related TBI. So let me tell you why. So a highly decorated TBI veterans all talk about the life cycle incurred by TBI and PTSD. Deny, delay, deceive, drugs, depression, and death. And anyone who served in the military knows, the biggest vitamin, the most prescribed vitamin in the military is vitamin N, Motrin. When you're injured in the military, they give it to you in bags of 800 milligram capsules. And then they overprescribe it until you urinate blood. When we look at our veterans with PTSD, the average veteran with PTSD or a TBI not only is taking 4 to 12 different drugs. Drugs are the first thing they do. Then they look at psychotherapy. Hyperbaric oxygen therapy is way down the list. What we're finding is hyperbaric oxygen therapy should be number 1 on the list because we're getting a tremendous benefit from that. And here's a good example. One of my master chiefs of SEAL Team 2, John Kirby, he retired. He's out ice skating as Santa Claus. He fell down on the ice trying to help a little girl, busted up and shattered his elbow. Within 3 weeks, John's elbow had gangrene. They put him on medication, they put him on antibiotics, they had him going in for injections twice a day, and it just got worse. So they were talking about amputation. We started meeting with a couple of the other doctors and talking to some folks, and they said, well, put him down in a dive. Put him in a dive chamber. Get him a hyperbaric chamber, throw him in there for 30 or 40 treatments, and let's see what happens. Within 5 treatments, the gangrene stopped dripping out of his arm. Within 10 treatments, it started to heal, and he was developing new bone growth. By the time he hit 40, they were no longer talking about amputation, no signs of gangrene, and it had healed up enough that he could actually use his elbow. The second dive he did, another series of 30 or 40 dives, he's back up where now he's going through physical therapy. He's back. You couldn't even tell that he had a problem where they were talking about amputating his arm. With our TBI and our PTSD veterans, it's very similar to the same thing. And what we have in Virginia, just in lost wages, we've got over $522 million in lost wages. I think, well, I'm not going to go into a tremendous amount of detail, but I could be here all day long on this. We want to join other states, Oklahoma, Arizona, Tennessee, Indiana, Kentucky, North Carolina, Florida, and Wyoming, that are doing the exact same thing. We know it works. I could literally give you another 20 examples standing here today with folks I served with, and one of them that used to serve with us when I was in the House. He's done 2 series of dives right now. Cognitive is firing again very well. He's back on top and really sharp. Where when he retired from the House, he started to have some cognitive issues. So I think this is a great bill, and I hope that y'all would support this.
Okay, thank you. I do not believe we have any questions from the committee. Is there anyone here to speak in favor or against the bill? Okay, I'm sorry. Yes, ma'am.
Thank you, Mr. Chair. I just wanted to say that I appreciate you bringing this bill. I think this is a great opportunity for us to treat our military, especially those with traumatic brain injuries and other injuries, with a treatment that is at the very least not harmful, and at the very best very helpful. And I appreciate it a lot.
Thank you.
Okay. The Speaker's office has sent a letter that if we report this bill, that it be referred to appropriations. But thank you. This is certainly an effort worth all of our support. And with that being said, I will entertain a motion.
I move a report with a recommendation that the full committee send it to Committee on Appropriations.
Okay. We have a motion to report and a second. Please vote.
Mr. Chairman, members of the committee, thank you very much. Have a fantastic day today.
Thank you. Have a good day. Okay, Senator Mason. We have.
Senate Bill 1513, Mr. Chairman.
Yes, sir. Senate Bill 1513.
There's an amendment,
Okay.
because I screwed up.
Yes, Mr. Chairman. There are 2 line amendments for this bill. On line 20, after assistance services, the, strike director and insert commissioner. And also on line 20, after rehabilitative services, strike the remainder of line 20 and through 2.2-438, on line 21.
Okay, do we have a motion to adopt the amendments? We have a motion, a second to adopt. All in favor, say aye. 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 All opposed? Senator Mason.
Thank you, Mr. Chairman. Mr. Chairman, Delegate Coyner and I are privileged to serve on the State Executive Council for Children's Services. And there's an offshoot of that, the state and local advisory team. They make a lot of local decisions, and then they meet to discuss policy. They interact with DARS mostly, and DARS is not on the SEC. So they just asked to have the commissioner of DARS, which was one of the amendments we erroneously called him director, just so that they send a representative, have someone they can work with on the council. The other, I thought putting the children's ombudsman, Eric Reynolds, who's doing outstanding work on here, would be a good idea. Someone raised the question as to whether he should be ex officio or voting. He asked the Attorney General, and the Attorney General said you ought not be on there at all, because you could be in a position of making policy and then ruling on or reviewing it. So we just said, you know what, let's take him off. And we're just trying to add the commissioner of DARS or representative.
Okay, thank you, Senator. Do we have any questions from the committee? All right, we have no one signed up online. Anyone here to speak in favor or against the bill? All right, I will enter. We have a motion to report in a second. Please vote. As amended.
As amended, sorry, let me fix that.
Well, please. Did you correct that? Just one moment.
No worries. You know, Mr. Chairman, it's tough over in the House, but the ball spot camera seems to be really egregious up here.
Okay, we have a motion. We have a motion and a second to report as amended. Please vote.
So we get 2 votes today. Oops, I'm sorry, that was a request. Let me. There we go.
Okay.
I hope I can make
All
the
right,
senator happy.
the bill passes 7-0. Thank you. Have a good day. Okay, next we have Senator Peake, Senate Bill 988.
Thank you, Mr. Chairman. This is a very, very simple bill trying to add the sale of a residential home between private parties as an exclusion under the Virginia Consumer Protection Act. And it's come up at a case I've had in Lynchburg, and we've seen it more and more in every breach of contract case. Attorneys are trying to put in some kind of a Virginia Consumer Protection Act claim because it allows them to get treble damages and attorney's fees. So they're turning in a basic breach of contract case and trying to claim the VCPA and fraud. And so this simple exclusion just says that somebody who's on a one-time sale of their residence to another individual, that doesn't come under the VCPA. They're not suppliers of homes. They're not building homes. They're not making homes. And now it may come up as a factual issue for the judge if they're flipping homes. So if they're selling 1 or 2 homes a year or a couple every other year, then it might come up. But it also has to be their residence. So even then, they would have to renovate it, stay in it. It would be their only house, and then sell it. So the intent of this is exclusion is to say, when some couple sells their house they've been living in for 5 or 10 years to another private individual, this should not be. And something goes wrong, and they have a real estate contract, and they claim a breach of that contract. It's not a VCPA claim. It's just a standard breach of contract claim. So this is as simple an exclusion as you can have and as specific as it can be. And I'm happy to answer any questions.
All right. Thank you, Senator. Any questions from the committee? We have no questions from the committee. We do have a substitute or technical line amendment. Sorry.
Yes, Mr. Chairman, this line amendment is just, like you said, purely technical in nature to correct an error in the title of the bill. On line 7 in the title, after the word between, we're going to strike private parties, semicolon contractors, and insert natural persons.
Okay, do we have a motion to adopt?
So move.
Do we have a second? Do we?
Just a question.
Yep.
Contractors is stricken, correct? This doesn't apply. Okay. Yeah, it's not supposed to apply to contractors. Okay. Thank you.
Okay, we have a motion to adopt the amendment. Can I have a second?
Second.
We have a second. All in favor, say aye.
Aye.
Aye. All opposed? Okay, I do not believe we have any questions from the committee. No one here to speak in favor or against the bill. I'll entertain a motion.
Mr. Chairman, I like simple bills, so I move the passage of this.
Second.
All right, we have a motion to pass a simple bill in a second. Please vote. All right, the bill passes 7-0. Thank you.
Thank you, Mr. Chairman.
All right, have a good day. Okay, next we have Senator Ruff. Wait, no, Senator Ruff's not on this. Okay. Okay, I'm sorry, Senator Hashmi.
Well, good afternoon, Mr. Chair and members of the committee. This is SB 934, and I want to begin just first of all by acknowledging and thanking all of our state employees who have worked so hard, most especially during these last couple of very challenging years through COVID, to do the work of the Commonwealth. All of the work that our state agencies engage in depended on the assiduous and diligent efforts of our state employees, so I certainly want to thank them. This is a fairly simple bill. It is an aspirational bill in terms of changing our telework opportunities for state employees from 20% to 45%. And just to share a little bit of the background, some of you may have been here. I'm not sure who was here back in 2004, but it was in 2004 under bipartisan effort under the administration of Governor Gilmore that we actually established the opportunity for state employees to engage in telework in the Commonwealth. And the goal at that point, the aspirational goal, was 20%. 2004 seems close to some of us, but if you remember, back in 2004, technologies were very nascent. We certainly didn't have Zoom, we barely had email, and we didn't have iPhones. And so if you think about the fact that back in 2004, the Commonwealth of Virginia thought, hey, we ought to give this opportunity for our state employees to telework. Well, the reason for that was to increase employment opportunities across the Commonwealth, most especially in our rural areas, giving opportunities for those citizens who wanted to work for our state government, but who did not want to leave their communities, their homes, their families, and move to either Northern Virginia or to Richmond. This was really to grant opportunities for wider and more productive engagement of individuals across the Commonwealth. So that was a very effective piece of legislation. We saw employment in our state agencies being able to spread across Virginia, and we also saw the necessary flexibility in order to ensure that the services and the needs of the Commonwealth and its citizens are met by individuals. Well, we're facing a considerable challenge, as you well know. Coming out of COVID, we are seeing private employers moving increasingly towards telework options. My own daughter left her employment with a department in Washington, D.C. in March of 2020. She's never set foot back in that office again, and she absolutely loves it. She can telework from her Fairfax home, and she does not have to do the difficult commute into D.C. Private employers are able to grant the flexibility, these options that are attracting and many, many skilled workers. And so the challenge for us as a Commonwealth is that we are facing challenges in retaining excellent employees and also attracting the best ones that we need to, because we're competing with private employers who can grant these options. What we've seen is that and research supports this, is that telework actually increases productivity, it increases employee satisfaction, and it really helps to retain a consistent and strong workforce. This bill, again, is aspirational, changing from 20%, our goal, to 45%. And in fact, research shows that nearly 66% of our state employees are, to some degree or another, engaging in telework. I'll just conclude by saying back in 1960, some of you may have been around in the 1960s. Captain James T. Kirk was able to negotiate intergalactic peace with the Klingons via Zoom and did so effectively. And so if we could do that in the 1960s, I think we can engage our employees in effective telework options going forward now. Thank you, Mr. Chair.
Okay, thank you. Do we have any questions from the committee? Yes, Delegate Walker.
So, Senator, if I could, and yes, Star Trek was one of my favorites, but that was television then. Let me ask you, is there anybody here from the state agency or administration in support of this bill? I know this is quite an increase in having been a former state employee there. So 20 to 45%. This is just for state agencies.
This is just for state agencies, and again, it's aspirational. It is not binding any agency to this figure, but we do have representative from the Virginia Government Employees Association.
Yes, sir.
Yes, ma'am. Mr. Chair, members of this committee, I think there's an important caveat that we've glossed over, and this is a percentage of eligible employees only. So these are employees that the agencies have determined have a role that's suitable for telework. So, for example, this would generally not be any consumer or customer-facing positions, or positions like correctional officers or maintenance folks that are working on our roads and streets. So the agencies have already made these determinations on what vocations are eligible, and we're just trying to codify 2/3 of what the Youngkin administration has already accomplished with their revised telework plan. So by their own numbers, we have 66% of eligible employees teleworking at this time. We're just trying to get 2/3 of the way up and just codify, again, this non-binding aspirational goal at 45%.
Thank you. I don't have any other questions.
Okay. Thank you, Chairman Leftwich.
So I don't disagree with the aspirational nature of the bill, but, and this may not be a universal thought, but I trust the governor to do what's best for the workforce in Virginia, and don't want to enact legislation that, you know, unintentionally ties his hands and allows him to do what he thinks is best under the circumstances. And that goes for, you know, we elect a new governor every 4 years, and that goes for who may come after him. And just need to leave, I think, these matters to the administration. So.
Okay, thank you. Delegate Adams.
Thank you, Mr. Chair. I would say, as a former state employee, one of the things that was very clear being there is that there is a lot of time spent in meetings that were particularly productive. So beyond this being like an access to work from rural areas, just working via telework can be a very efficient way to work. Secondarily, we had talked very much, and this was back in 2015, 2016, about the brain drain that was coming to state government, meaning people that were going to age out or retire with this wealth of knowledge. And what we are needing then are younger people with, you know, a lot of intellect and an interest in public service. And so I think, you know, given all of the economic challenges and all of the technological advantages, we should be help facilitating the government to have its brightest and best who also want to do public service and facilitate a way for them to work in a work setting that is comfortable for new generations. So I think it makes a lot of sense, aspirational or not, that we're looking in this direction and how effective it can be. Thank you, Mr. Chair.
Okay, yes, Delegate Runyon.
Thank you, Mr. Chair. And just speaking to the matter and to the Senator, I appreciate you bringing forward, and I appreciate the delegates' most recent comments about kind of the history, but also appreciate Chairman Leftwich's comments. And I do find it interesting that all the conversation that we've had is about the state workers, and I truly appreciate our state workers. We have some tremendous state workers, and the folks that I represent in my district, I am so proud to be able to be associated with them. But the part that's left out in this conversation is the constituent service. I've spent the last 4 years, particularly the last 3 years, dealing with issues where I've had constituents that have been unable to connect with the agencies. And I think there's a multitude of challenges, and I would suggest to you that maybe the policy ought to be looked back. How do we achieve the outcomes that we wish to, which is provide top-notch, world-class service to our constituents, and then decide what's the appropriate level of teleworking to be. 45% seems like an awful high number to me. And when I had conversations with some folks that were trying to support this bill earlier, to be frank about it, I didn't get comfortable with that number. Made a lot of sense. And so again, I respect what our state agencies, our state workers do, but I think for me, it needs to be a higher level of attention paid to the constituents. Thank you, Mr. Chair.
Okay. Thank you. Senator, do you have another comment?
No, just, Mr. Chair and Delegate Runyon, I would just respond that it seems that we already, under our new policy and our new administration, it looks like we have about 66 employees that are, 66%, excuse me, 66% of our state employees are already engaged in some form of telework, and this would just codify the goal that we keep moving forward in this direction. So I think we're already doing it, and I think we're doing it fairly effectively, and we need to continue to address the needs of our agencies and our employees. Thank you, Mr. Chair.
Okay, thank you. And Senator, I certainly appreciate the intent here and the merit of the bill. I can certainly see the benefits in rural areas, but just to reiterate some of Chairman Leftwich's comments, that's a significant increase. And, you know, personally, I've not received any feedback from the administration, and you know, ultimately, we would like to have some feedback from the administration on where they stand on this. And so, you know, from my perspective, I think that in order for me to support this, I need to hear from the administration on where they stand on this. And so, with that being said, I'll entertain a motion.
Mr. Chairman.
We do not have anyone signed up online to speak, but if there is someone, is someone signed up online?
Well, Mr. Chairman, if I might add some remarks on behalf of the Virginia Government Employees Association.
Yes, sir. Yes.
And again, my name is Dylan Bishop. The state workforce has had a longstanding recruitment and retention problem, very much predating the COVID-19 pandemic. And when JLARC and DHRM have studied the retention issues, there's two confounding variables that are most prevalent. Of course, compensation, but the second most cited reason for leaving state employment is lack of flexible work opportunities. And the brain drain is very real. We've got over a quarter of our state workforce that's eligible for retirement right now. And the younger generation just simply is not interested based on the pay and the lack of compensation available. So if we're truly concerned about constituent services, we need to ensure that we have folks in those positions to do those jobs. And right now we're up against a wall, or for a more apt metaphor, we're on the edge of a cliff, and we are about to lose a significant number of our state employees to retirement. And we just hope that we've got folks in those positions to fill that void and provide those services to our constituents. I'd just like to add that if you've reviewed the fiscal impact statement, the Commonwealth already has the existing technology and infrastructure to provide this because of what we've gone through with the COVID-19 pandemic. So there's absolutely no fiscal impact. And this bill did pass 32-8 out of the Senate on a bipartisan basis, so we just ask for your favorable consideration. Thank you.
Okay, thank you. And again, I certainly appreciate your feedback, but we've got to have some sort of feedback from the administration on where they stand on this, and they're not here today. And so, with that being said, I'll entertain a motion.
Mr. Chairman.
Yes, sir.
I move that we lay this on the table. I'm not comfortable with what I heard today, and I share the same comments as Delegate Runyon and Chairman Leftwich as well. So the motion is to lay it on the table.
Second.
Okay, we have a motion and a second to lay the bill on the table. Please vote.
Thank you, Mr. Chair.
All right, thank you, Senator. Have a good day. Okay, that completes our docket. Meeting adjourned. Thank you.